Hello folks, and welcome back to this mini-series. In this presentation, I'm going to be diving into the bills of exchange and how we can apply this now to our situation to access our remedies. Before we dive into this, I've made extensive notes and commentaries on some of these key points. I didn't miss it, okay, which is obviously what you see here in red. That will be very, very enlightening, as it was for me revisiting this subject. But before we dive into this, just want to quickly recap. Obviously, part one, the key points, went through the banker-customer relationship. Okay, that showed that money is held on an account to the credit of the account owner, and it's otherwise basically a loan and a debt that is owed by the bank to the customer. Okay, so he can do with those funds as he pleases. It's not held in bailment, custody, trust, and there's no principal-agent relationship apart from when fulfilling and clearing checks, etc. We had obviously banks as credit creators, where the banks do not take deposits and they do not lend money. All right, they create money on account at zero balance, and as I said before, they take loans from the public to do with that as they please. And then whenever we make a demand, we are then able to draw down the debt the bank owes us. So it's a special debtor-creditor relationship. Then we had in the previous presentation, went through the accounts, the double entry bookkeeping system, the accrual accounting as well, and this concept of a constructive trust, okay, which is really important in regards to how a banker would behave when he knows that, okay, we've got a standard personal account here or business account. The duties of the banker aren't really that concerned, okay, in regards to, how he manages that account and works with the owner of those accounts, as compared to a banker knowing that it is a trust account, because through knowing it's a trust account, he can be liable, okay, under what's called a constructive trust. And that is basically the bridge that makes the banker an agent for the trustees. Okay, so he can be otherwise in knowing receipts or knowingly assisting in the misappropriation of trust funds if the trustees are acting fraudulently. Okay, and this is why the bankers always ask for the trust declaration certificate of trust and the trustees' powers, so they can take a copy of that and make sure that whenever the trustees are dealing with that account and ordering the banker to transfer this or invest in that and do this, withdraw that they are operating within the confines of the trust indenture. Okay, so extra duty of care is taken by the banker, knowing that, to make sure that, right, these guys, these trustees who are managing this account are acting in the best interest of the beneficiaries. Okay, so that's very, very interesting and very, very important to know, especially when formulating your language and knowing what you're dealing with and who you're speaking with over what kind of account is being managed. All right. But take nothing away from the banker-customer relationship still exists in that sense, because the money standing to the credit of the trust account, okay, that the trustees are managing for the beneficiary, are still entered in the double book entry system, okay, and is able to be used by the banker to go off and invest in whatever he pleases. Okay, it's only when fulfilling orders and liaising with the trustees that he's got to be extra careful. Okay, it doesn't give the banker the right then to make an investment decision on behalf of the trustees. No, the trustees still have that ultimate decision, but it's whenever he's liaising and dealing with any orders, okay, by the trustees, that extension of liability can extend to him through the form of a constructive trust, where he'll be seen as an agent of a trustee and can be sued in such capacity if the beneficiary, for instance, finds out that the trustees have been misappropriating the funds. That liability can then extend to the banker and can trace all the assets back into the banker who is managing that account on behalf of the trustees and assisting them in doing so. Okay, so again, another very, very important concept to take away, guys, given our situation and where we find ourselves in with the kind of accounts that we've got set up on the private side and the public side, which ties into, again, another concept that I touched on before. Through the eyes of a banker, an administrator and an executor are basically the same, one and the same, whereas obviously as soon as the deceased estate has been completed, then whatever's left over normally, right, through the probate process, normally those individuals who are executors and administrators shift into a trustee setup under a trust, which is then managed on behalf of the beneficiaries. Okay, whatever res is left over from the will, as it were, in a conventional kind of setup of probate in a deceased estate, that the shift from executor administrator happens to trustee normally once the probate is complete. Okay, So from the eyes of a banker, obviously a trustee relationship is completely different to one that's executor administrator. And now knowing that the government are administrating all these deceased estates, okay, which is our straw men and women and accounts, okay, on the public side as executors and administrators, we also have this concept of them being trustees too. And I asked the question that at what point do they become trustees in this kind of duplicitous relationship where two seem to be running at the same time? And I didn't realize, obviously, until going back over it, that of course it's all linked to the private side and the public side. Okay, so the public side, we have the decadent estate, which is our straw man, which is where they're hoping us, okay, are basically going to step in as surety for that straw man and act and play dead, okay, and think that is us. Whereas on the private side, this is where the living beneficiary wakes up, rises up, and comes in and rebuts all their assumptions, presumptions, and holds them then in the capacity of trustee, which is where they're bound to perform in the best interests of the beneficiary who's come back to life. Okay, and this goes back into the Holy Trinity, like I said before, in understanding who we are and how it's all codified in the movies, like The Bourne Identity and, the Sedicovy Act, 1666. You need to let them know that you've come back to life, so you can make that transition from the public realm into the private realm to access your remedies as a beneficiary, the only contributing beneficiary of such with the prepaid and limited exemption account, the foreign side is trust, okay, that they're administering on your behalf. Okay, if not, everyone's still stuck in the public, okay, acting as surety for, agent for this deceased estate. And that's where these guys are playing the role of administrators and executors, executing the law onto the dead, okay, whereas in reality, the equity and the remedy lies on the private side. Once we come back to life, learn how to manage our estates and our papers and accept our bills on behalf of this public dead fictional entity and send it to the right parties, our trustees, who hold legal title to the account for set off for our benefit. Okay, so I hope that has clarified that, as it had done with me when revisiting, because I do watch my presentations over 3 or 4 times, which I highly recommend you guys. If you're only watching it through once, then you're at a severe disadvantage, because I've not been able to retain any of this information from other gurus as well, but just watching through once, 4 or 5 times minimum, with every single Bill Turner presentation, Winston Shrout, you name it, Dean Clifford, David Warren Miller, all these folks have come before, right? PJP, you just got to rinse and repeat. It's painful work, okay? Growing neurons under the law of facilitation, whatever it's called, it does require a lot of energy, but it's so worth it in the end, okay? Because it just naturally builds on itself and it becomes easier and easier and easier. All right, so with that being said, covering those important points as a recap, let's dive into the bills of exchange now and how it can apply to us given our situation. So a creditor typically issues a bill of exchange, right? Whereas a debtor issues a promissory note. Okay, so good to remember when trying to formulate, okay, the scenario with drawee, drawer, payee, payor, etc. Okay, so creditor typically issues a bill of exchange, whereas a debtor issues a promissory note. For our situation, the maker of a bill would typically be a utilities company, council, police, tax department, anyone coming after the straw man, basically. Okay, the drawee they address the bill to would be, the deceased estate, the straw man. The payee of the bill would be the maker, okay, i.e. the company who sent you the bill, which could be paid into a third-party revenue fund. Okay, so they could be fishing on behalf of some other creditor as well that they're going to negotiate that bill to or endorse that bill to. And the payor is the one who steps in as surety for the straw man to pay the bill. So the drawee is often the payor's bank who holds the account to be debited on behalf of the drawee. And they're hoping you, me, the living being, steps in as surety to foot the bill. So you have 2 options: pay the bill from your hard-earned cash, or have the Treasury set off / discharge the bill on your behalf. Again, that's the public versus private realm. Another scenario, this is all assuming you have your set-off bonds with the Treasury and UCC filing done correctly, etc. When acquiring assets and accepting for value a purchase agreement, the purchase agreement would be a bill in this instance, which you can then accept, endorse, charge the instrument and send to your drawee for set off, okay, which is the Treasury. The Treasury is the drawee / bank on the private side, and your hard-earned cash / labour held on deposit with your retail bank account, the public side. And now I've talked about this previously as well, that I think within the retail banks too, there is obviously a private side, okay, but you can only unlock that again through language, okay, negotiating with these folks. So it's just a matter of developing the understanding of set-off, bonds, status correction, UCC, PPSR, letter writing, and acceptance. Once you have everything established with the Treasury, that will give you the confidence when executing all of this. All right, so let's go into the notes now, taking out the book surrounding bills of exchange. Suppose that D wants to on-sell the note to E. Okay, how does E know that D is entitled to the note? Again, the best way to achieve this is for A to write on the note itself something like pay this note to D and sign it. D then writes pay this note to E and signs it. These notes of transfer are called endorsements. Okay, the word is an older form of endorsement that is still used in legislation and in practice. A note being a bill of exchange in this sense, which is a species of negotiable instrument. Issues with the rights of parties in a bill of exchange was historically answered by the customs of merchants and the decisions of commercial courts over many years. Legislation was a latecomer. In 1878, Mackenzie Chalmers published a digest of the law relating to bills of exchange. The digest was so impressive that Chalmers was asked to codify the law relating bills. The result was the Bills of Exchange Act 1882 in the UK, which has been referred to as the best drafted Act of Parliament ever passed, okay, per McKinnon LJ in Bank Polski versus KG Mulder and Co. back in 1942. The Act was subsequently copied in most English-speaking jurisdictions, including Australia. You'll see in the UCC in America, all the acts in Canada, most of the Commonwealth countries, right, it'll be verbatim, just copy and pasted, but just moved around slightly in regards to referencing the section in which that particular statement is printed. So a bill of exchange is a negotiable instrument, one of three important negotiable instruments in Australia. You've got the Bills of Exchange, promissory notes and cheques. Until 1987, all three were governed by the Bills of Exchange Act 1909. The Checks and Payment Orders Act came into operation 1st of July 1987, and in 1998, the Act was renamed the Cheques Act 1986. Cheques drawn on or after the 1st of July 1987 are governed by the Cheques Act 1986. It's quite interesting. Cheque is literally just a promissory note, okay, as we went over in the previous presentation, and I'm pretty sure I'll make a note on this here too. So although cheques are now subject to the Cheques Act 1986, the Bills of Exchange Act 1909 still contains Part 3, checks on a banker, and still contains the definition of a cheque. The definition in the Cheques Act 1986, although similar, is not quite the same as that of Bills of Exchange Act 1909. It is possible that an instrument may be a cheque within the definition of the Bills of Exchange Act 1909, but not the Cheques Act 1986. Interesting note from Winston Strout's seminar is that a cheque usually involves three parties, right? You have the drawer, the drawee, and the payee. Because each cheque is signed as authorised representative and the bank actually just being an extension of the strawman account, there are only really two entities involved, making it a promissory note, which can then actually be used to securitise and sell on the markets, which is exactly what these guys do. They monetize anything and everything they can get their hands on, right? That has name, date, amount, and signature on it. So the concept of negotiation, the essence of a negotiable instrument is that the debt which it represents should be easily, cheaply, and freely transferable. Negotiable instruments were originally developed for the purpose of extending credit and obtaining payment in international sales transactions. In the form of bills of exchange and promissory notes, they now play a significant role in the mobilization of short-term capital. In order to facilitate easy transferability, the usual rules about the transfer of property do not apply to negotiable instruments. Okay, the rule, a person cannot give a better title than they hold, which is so fundamental to the common law of property, is the exception rather than the rule in negotiable instruments law. The fundamental position in the latter is that a bona fide purchaser for value with no notice of defect of title will get good title even if the transferor has a defective title or, in some instances, no title at all. Okay, so meaning if the holder possessing the bill of exchange obtained it through someone who did not have rights to the instrument will have good title to the instrument and the right to present for payment. Okay, so hopefully that clarifies it. I've done my best to try and clarify some of these terms. Okay, that for me initially was just like a bit of a head spin. But like I said, this is the act that you really need to sit down and understand fully. But once you do it, it's like riding a bike and it's no going back. And it's very powerful to know this stuff, given our situation and the remedy, which we'll touch on later. So transfer by endorsement / delivery, the first characteristic is that the rights embodied in the negotiable instrument are transferred by delivery and in some cases endorsement. Endorsement signifies the signature on the instrument, usually on the back of the person who is transferor. The addition of the endorsement will usually make the endorser a surety for payment, as well as transferring the right to the payment. The process of transfer by endorsement and delivery is called negotiation. Okay, so what we are doing when signing and accepting a bill for value is we are one, endorsing it, and two, transferring the right to the payment. Okay, the endorsement can happen in one of two ways. You can be signing in a representative capacity, which limits our liability and not making us surety, i.e. using PP, our strawman birth certificate registration number, or by the order of, our strawman birth certificate registration number, which is identifying the account from which the funds should be drawn from by, your giving name, your living name, or sign as authorized rep for the strawman birth certificate registration number. Okay, there's different variations of signing with that liability in order to charge the instrument, but charge it in a way that you're not becoming surety, but otherwise transferring the surety over to the Treasury, where the private exemption set-off account is being managed, the bank. Then we've got two, signing by accommodation, okay, which makes the person signing it surety and thus liable to pay. So my suggestion is to make maybe sign by accommodation, for instance, the name of the father, strawman, okay, with again the birth certificate registration number and or your strawman birth certificate registration number. Okay, so that's identifying and making it very clear that right, that these entities are ens legis corporate fictions that otherwise are bank accounts, okay? And the birth certificate registration number is the prepaid foreign sellers trust unlimited exemption account. Then you have the national insurance number or social security number is another account, okay, but that must be charged up with bonds. Okay, so you can play this one or two ways. We can have even both. You can have the national insurance account charged up with bonds. Okay, then you can issue another set of bonds that are working with the birth certificate registration account. Okay, that helps to draw out the money from that account. It's almost like a pass-through. That bond ends up becoming the order for the trustees to pass through and access those credits for your benefit. Okay, or you can have them both listed on the same bond, in other words, but when you're doing your acceptance, these are just different ways in which you can try out, okay, on these bills. So both charges the instrument with our life force, which turns that bill into currency, and both shifts the surety onto the government and Treasury, that they can now act through your surname or strawman, because all these entities need agents, okay, to give it life, that you're then passing on the liability for them to act through, okay, for your benefit, the living individual. So transferring the right to the payment will become clear later, but it allows the transfer of liability to rest on the Treasury to pay the debt and reimburse the drawee, which is the Treasury, if needs be. Examples of acceptance language will be shown later. So transferee able to sue in own name. So the second characteristic of a negotiable instrument is that the person who is entitled to the instrument, called the holder, may sue in his or her own name. This is an important exception to the common law doctrine of privity of contract, for it is not necessary to sue the person from whom the holder took the instrument. The holder may choose to sue any one or all of the parties who are liable on the instrument. The procedure for suing on a bill is particularly simple. The plaintiff need only produce the bill, which will show on its face and back that the plaintiff is the presumed holder. Defences are very limited, and the plaintiff holder will usually be entitled to summary judgment. Okay, one way of viewing a bill of exchange is that it represents a debt which may be transferred from person to person by negotiation. Each person who endorses a bill is liable to the holder. Now, if we look who endorses these negotiable instruments we use as cash today, who is liable? Okay, it's the government, the central banks, the Treasury, as they promise to pay for all debt in the future when we come back to substance-based money. Okay, the government of the future promise, and they issued that promise and endorsed it for it to be used as cash. The debtor always issues the promise. Okay, and I think I've put down here some examples of the signature. So this is basically a negotiable instrument that has been endorsed by who? The debtor. This is what? Promissory note. Who endorses a promissory note? The debtor. So we've got Chief Cashier for England, for instance, and you have obviously for Australia, the Secretary of the Treasury, Governor of the Reserve Bank of Australia. So these guys are all the future promise, okay? Now just remember, I'll pull up some of Winston Strout's notes, because he goes into this as well, which is quite interesting to bring up. I'll just find, just give us 2 seconds. Yeah, so whoever creates liability has to bring the remedy to the problem. And this ties into acceptance too, which is all part of this presentation. So acceptance for value is private administrative procedure, and this process turns that paper into currency. And you can see the very rudimentary way in which that is done. There's many different ways you can do it, and you'll find another way later that I'll show you. Anything else than acceptance in bankruptcy leads to dishonor and liquidation. Okay, your dishonor creates the funds in the involuntary bankruptcy. Only remedy in bankruptcy is acceptance, accepting the charge, accepting the Christ. You are guilty because you are the creditor of the national bankruptcy, and the creditor has the unlimited ultimate liability to settle all the accounts, right? That's the power we have. And there's just a few other ones. I just want to, so use our exemption as surety, use our surname as surety, that's the Crown, use the birth certificate as security for the bond. That way the fiction can operate fully charged, create a good battery to get things done. There's so many pearls of wisdom in his presentations, just like one key loaner series. So bonds allow you to instruct the agency, an agent you issued the bond to act on your behalf whilst being indemnified up to the value of the bond as stipulated in the bond agreement. So you've gone through. So anytime in the public, when a public debt has been created, the offset has been created as well, and it's being held by someone. I think we went through this in the previous presentation, but it's good to go over it again. Since you don't know who that someone is to make the presentment, this is when obviously you can deal with the IRS to figure out who's operating that foreign seller's trust. But once you get your bonds established at the Treasury, you can just go through the Treasury. It's no biggie. But you can then go even bigger and go up to the IMF at the international creditor level if you so wish, and start to knock on the door with these folks. Okay, and that's there was one note in here about the bankruptcy, but anyway, the future promise, okay, which I think is at the top. Let me go back to the top, 2 seconds. Yeah, here we are. So remedy that was left by the government was the discharge of public debt into the future. Okay, government said we will accept limited liability in all the debts of all the citizens, which meant they accepted the liability for the debts. When you discharge a debt, the government is the future event that promised to pay whenever substance comes back into use and commerce. Okay, so there you go. Straight out the horse's mouth, Winston Shrout. So we have the holder of a bill of exchange must only plead that he or she is a holder and that the signature of the defendant is on the bill in a position which makes the defendant liable. The plaintiff is then entitled to summary judgment for the face value of the instrument unless the defendant can obtain the leave of the court to defend. This will not be granted lightly, for the rule is that negotiable instruments are to be treated as cash unless there are exceptional circumstances. Other negotiable instruments, we have bills of exchange, promissory notes and cheques, are not the only financial instruments which are negotiable. The Bills of Exchange Act 1909 and the Cheques Act 1986 both consider dividend warrants, that is, warrant issued by a company to enable a shareholder to obtain dividends from the company's bank. That's codified in Section 101, and Cheques Act in Section 118. Other instruments which have been held to be negotiable include short-term bearer securities issued by foreign or domestic governments, bearer debentures issued by corporations, some government and corporate bonds, warehouse certificates, and negotiable certificates of deposit, and our birth certificates. That is a negotiable instrument. Okay, that can be used as a check, that can be used as a promissory note, it can be used as a bond. All right, so the sky's really the limit, guys, of this. It's just a matter of, again, go back to grammar, logic, rhetoric, understanding now the technologies you have and how best to put a plan together to unlock it. I'm sure this information is helping to aid in providing you with those solutions. So we've got a few definitions taken out of LexisNexis in Australia, as well as Black's Law surrounding note. Okay, it's generally a brief written or printed statement giving particulars or information. We've got bills of exchange and other negotiable instruments. One, a promissory note, okay, paper money or banknote, a tradable security such as the Treasury note issued by the Commonwealth Government or the promissory note issued by companies and semi-government authorities. We have notes, written promise by one party, the maker, to pay money to another party, the payee, or to bearer. A note is a two-way party negotiable instrument, unlike a draft, okay, which is a three-party instrument. You can pause and read through that in your own time. It's pretty rudimentary, folks. I'll just read what's highlighted. So this is under promissory note again. An unconditional promise in writing made by one person to another, signed by the maker, engaged to pay a sum certain of money to or to the order of a specified person or to the bearer. And we have the maker must intend to make a contractual promise to pay on the instrument distinct from any promise in an underlying transaction. Until endorsed by the maker, an instrument payable to the maker's order is not a promissory note. And we have a promissory note may contain a pledge of collateral security with authority to sell or dispose. Okay, such notes are negotiable instruments and are used mainly as security for money lending transactions. Now, the time to maturity when payment becomes due is usually 90, 120 or 180 days. Now we see that often in court cases, because this is the whole deal surrounding these notes and securities. Okay, after certain days, they become securitized, etc., when they reach maturity. And that's what has otherwise been an issue whenever there's a claim being brought against you, etc. Okay, that's why these things normally happen in 90, 120, 180-day increments with summons and stuff like this, reappearances, whatever, and presentments. So in relation to the money lending transactions, okay, how it can be used as a pledge of collateral security, just like in a mortgage, that is a promissory note, okay, with a pledge of collateral security in the form of the house you purchase. The banks create the credit from an account of zero balance. They give you the loan through their off-ledger lawyers trust account that pays for the house to make it look like it's come from somewhere else and that it hasn't been created from nothing. And the banks then bundle your promissory note with others, securitize it, and sell it on the markets at a discount, then act as a pass-through for the holder of those securities for your repayment of the principal plus interest. So they're getting double payment for the thing. Not only are you paying back the original promissory note that's been created on an account of zero balance, they've also sold that promissory note at a discount already in the market. So they've monetized it, okay, which makes for the movement of short-term capital. So that liquidates the note, and so they trade that for cash, and then they act as a pass-through for the person holding that note, who's entitled to receive what? Your sweat equity, your labor, which is to the amount of whatever the principal is on the promissory note, the mortgage, plus interest. And if you don't pay, because it's got a lien against your house, which is just a fictional title that the house is linked to, again, under colour of law, colour of title, that they can come and seize the title, okay? Not the actual house, but everyone ends up playing along with this fictional game and thinking that, oh my God, they're coming to seize the house, they can change the locks, and that's all breach. They're not allowed to do that. So it's all just on paper anyway, okay? So we've got draft, noun, a preliminary version of a written document. 2, verb, to create a preliminary version of a written document. 3, verb, the preparation of a document in a rough or preliminary fashion before the final version of the document is produced. Under the bills of exchange and other negotiable instruments, a bill of exchange purchased from a bank to settle a transaction. In modern usage, usually an international transaction. We've got draft is an unconditional written order signed by one person, the drawer, directing another person, the drawee or payor, to pay a certain sum of money on demand or at a definite time to a third person, the payee or to bearer. The check is the most common example of a draft, also spelt draft, okay? We have to draw is a verb, is to create and sign a draft, all right? To prepare or frame a legal document, draw up a will, or to take out money from a bank, treasury, or depository, okay? To select a jury, that's from Black's Law. Then we have the drawer, is someone who directs a person or entity, usually a bank, to pay a sum of money stated in an instrument. For example, a person who writes a check, okay? And then under the UCC, a person who signs or is identified in the draft as a person ordering payment. It's interesting, they say here, someone who directs a person or entity, usually a bank, to pay a sum of money stated in an instrument, because given the system of where all the credits are and where all the so-called money is, the cash is, right? Where is it? It's in a bank. And so when they're addressing that entity, your entity, the straw man, that is a bank. It is a bank account. Okay, and it's either going to come from one or two places: your public sweat equity bank account or your private unlimited exemption set-off account. And that's you know what I mean? That's where we have to go to get out of the bankruptcy. So our sweat equity is no longer pledged as surety for all the debt, and we can find our remedy. But interesting how they say there, this concept again, we are sour, we are the bank, okay? And all these vessels are just bank accounts. Banking through the monarch, the monetary system, right? The moonai, the monopoly, that is the lord of this realm, okay? Banking, that's the conduit, as I said before, of our ability to be able to manifest our ideas and dreams into reality down here under time, old man Chronos, where everything is frozen and slowed down. The manifestation process is subject to time now, okay, under these contracts and money, debt-based fiat currency system. So we have a drawee, a person on whom a negotiable instrument such as a bill of exchange or check is drawn, a person to whom a negotiable instrument is addressed. See also sent by the drawee, bill of exchange, check, drawee institution, negotiable instrument. Then we have a drawee as the person or entity that a draft is directed to, and that is requested to pay the amount stated on it. The drawee is usually, again, a bank that is directed to pay a sum of money on an instrument, also termed pay your bank. The Treasury is our bank on the private side, as we know. So we've got a bill is a legislative document in the form of a proposed act of Parliament that has not yet been passed by Parliament or received royal assent. Commonwealth bills require approval by the House of Representatives and the Senate and assent by the Governor General for enactment. State bills require approval by the relevant houses, again the assent of the state governor. Northern Territory bills require approval by the Legislative Assembly and the Administrator or Governor General, while Australian Capital Territory bills require only the approval of the Legislative Assembly, although they may be disallowed by the Governor General within 6 months. A bill tabled before Parliament may be amended extensively before enactment. A bill is typically drafted in separate clauses, each of which can stand on its own for the purposes of being debated in Parliament. Okay, and my note here is a drawer of a bill, in this sense, is the government, drawees, the citizens and the taxpayers, and the payee is the government revenue fund. So it is my belief, though, that they fund the bill through their appropriation bills, which dips into our accounts on the private side, which prepays for everything, and the revenue hunting through taxes, fines, fees, etc. as a means in which to service the interest due on the national debt to the holders of government bonds, majority of which are the elite, BlackRock, hedge funds, etc. So a bill is a noun, a formal written complaint, such as a court paper requesting some specific action for reasons alleged, to an equitable pleading by which a claimant brings a claim in a court of equity. Now you guys can read through this in your own time, these different definitions. You have an administration bill. It's a bill drafted and submitted by the executive branch. Then the appropriation bill is a bill that authorizes governmental expenditures. The federal government cannot spend money unless Congress has appropriated the funds. Okay, so everything costs money in this system. Even the bills they pass in Parliament needs a payment. Okay, it needs to be settled and closed. And so if it isn't done through the private set-off, then it goes out into the public to be raised as revenue, basically, which otherwise is, again, this kind of double dipping process that goes on. And that goes towards servicing the interest due and all the debt on the public side. So private bill, a bill relating to a matter of personal or local interest only. There's a few I've chucked in there that kind of trivial, quite interesting. An enacted statute, okay, we've got 5, an itemized list of charges, like an invoice. This is all under the definition of bill still. You've got a bearer bill, which is a bill of exchange that is either expressly or by law payable to the person who possesses it. Okay, then we have a bill payable at sight, a bill of exchange requiring payment immediately upon its presentation. These you can go through in your own time. We've got bill of credit, is a legal tender in the form of paper issued by a state and involving the faith of the state, designated to circulate as money in the ordinary uses of business. Okay, and that's basically our fiat currency today. Got a bit of entry there, bit of exchange again. Guys, go through that in your own time. It's all pretty rudimentary. Bit of exchange, unconditional order in writing. We've gone through this many times. A bill may be drawn payable to or to the order of the drawer or the drawee. And we have a bill of sale, which again, once you folks understand this concept of acceptance in regards to setting off bills, then you can certainly go and acquire assets by setting off a bill, which in the form of a purchase agreement, okay, with a vendor, a merchant, for instance, say, a car dealership or for even a house possibly, that you can do your acceptance on the bill and then go through the motions of sending it to your bank, who's the drawee, to have it set off. Okay, so a bit of sale is an instrument for conveying title to personal property, absolutely, or by way of security. So the expression bill of sale includes bills of sale, assignments, transfers, declarations of trust without transfer, inventories of goods with receipts thereto attached or receipts for purchase monies of goods and other assurances of personal chattels, and also powers of attorney, authorities or licenses to take possession of personal chattels as security for any debt and also any agreement, whether intended or not, to be followed by the execution of any other instrument by which a right and equity to any personal chattels or to any charge or security thereon shall be conferred. Then we have a transfer. Bill of sale is a transfer, may be either an absolute assignment by way of a gift or sale, or an assignment by way of mortgage or security only. But in either case, when a written document of any sort is used to effect the transfer, the document is called technically a bill of sale. So certain instruments are known to lack some essential features of negotiability, even though they are easily transferable. These include share certificates, bills of lading, storage receipts, and money or postal orders. It should also be noted that receipts, IOUs, and debentures, which either create or acknowledge an indebtedness, are not negotiable, even though there may be a significant market for them. If the jury does not accept the bill, then he or she may not be sued on the bill. An instrument that does not contain an unconditional order is not a bill of exchange. Okay, the reasons that the order must be unconditional were explained in Carless versus Francourts back in 1794, where it would perplex the commercial transactions of mankind if paper securities of this kind were issued out into the world encumbered with conditions and contingencies, and if the persons to whom they were offered in negotiation were obliged to inquire when these uncertain events will probably be reduced to certainty. So an instrument which orders any act to be done in addition to the payment of money is not a bill of exchange. Okay, you've got Section 8.3 of the Bill of Exchange Act here in Australia's 1909, provides that an order to pay out of a particular fund is not unconditional. Okay, the reason is that the fund may be inadequate to meet the payment or may cease to exist at the time when the bill is to be paid. Cite refers to the presentment of the bill to the jury for acceptance. Okay, a bill is accepted when the jury signs in a way that signifies that he or she accepts their liability to pay the bill at the indicated time. If the jury refuses to do this, the bill is said to be dishonored by non-acceptance. Okay, now acceptance definition. Okay, the act of assenting to, agreeing, receiving, or taking something offered. Under the bills of exchange and other negotiable instruments, we have the signification by a juree of an assent to the order of a juror, requiring the jury to sign the bill, and an expression that the jury's promise will be performed only by money payment. Okay, so when they send a bill to us, they're addressing the juree, which is our straw man. So we have acceptance by silence. Okay, it's another important concept. You guys can pause and read for that in your own time or download the PDF. Acceptance of an offer, not by explicit words, but through the lack of an offeree response in circumstances in which the relationship between the offerer and the offeree justifies both the offerer's reasonable conclusion that the lack of one signals acceptance. So ordinarily, silence does not give rise to an acceptance of an offer. This is my comment. This is one of the most important and powerful tools for any sovereign to utilize when seeking acceptance, either with our straw man or with any other person, office, agency, and agent within the public realm, when stipulated in the letter, contract that silence/non-response is acquiescence. Then you have your agreement and contract in place, which is the law and equity. Okay, you have a paper trail, proof of postage and delivery, as well as your own record. So simple, but so effective. Okay, that it is often overlooked and underutilized for people when formulating claims agreements to safeguard your freedoms and terms and conditions. For example, tax exempt status, permit bonds, set-off bonds, etc. Okay, it is such a powerful tool to utilize. But again, going back to logic, grammar, rhetoric. Okay, can you now put forth this technology? How can you utilize that? That's all down to each and every one of you. So you can only do what you understand. Can't do anything else. Copy and paste it, it has no power if you don't understand it. And that understanding will give you your own unique spin on things. And the people receiving that will know that you know, that you're not just copying and pasting. So 3, under acceptance, again, I believe this is still, running under acceptance. The acceptance becomes operative upon notification of delivery. That's what, the postal or delivery, postal mechanics, very important in this process. And then this is interest 1, acceptance au besoin, which is in case of need, an acceptance by one who has agreed to pay the draft in case the jury fails to do so. It's basically a surety kind of setup. We have conditional acceptance, an agreement to pay a draft on the occurrence or non-occurrence of a particular event. Certainly a good tactic to remain in honour whilst you question the debt obligation with the goal of having it set off, discharged, settled and closed. It's the only way that we can come in under the system of bankruptcy, debtor, creditor, and remain in honour. Conditional acceptance. Remember, we'll go all the way back to what Bill Turner advocated. That's where I learned this from. That the only remedy that we have is either to accept or conditionally accept. If you fall silent, you're in dishonour. And if you argue, dispute it, you're in dishonour. Okay, and so now obviously we're with the knowledge I had back then under the technologies of conditional acceptance, and then only knowing now with the whole setup of the accounts, now to access that through bonds and using our birth certificate security, that we can now accept the charge. And that's what the whole fundamental basis of the Advanced Treasury Pack is trying to enlighten individuals of, the ability to accept now and set off the debt on the public side by accessing the private prepaid limited exemption account. So again, more definitions there. Insurance as well as a big key one to understand fully. You've got the acceptor as a person or entity that accepts a negotiable instrument and agrees to be primarily responsible for its payment or performance. As the term maker denotes the promiser in a note and him only, so the term acceptor in the terminology of law merchant denotes the drawee of a bill, foreign or inland, who has bound himself in due form of law to pay the bill according to its tenor, okay, to the payee or any subsequent holder in due course. Again, we've got some more definitions here. As there must be an order in the case of a check and a bill of exchange, so there must be a promise in order for an instrument to be a promissory note. However, remember, because we sign in a representative capacity and the bank is often the drawee of a check, which is our strawman account, there are only really two parties to a check. So you've got the maker, drawer, payor is the strawman, and the drawee and the payor is also the strawman's bank account. Okay, so one and the two are the same. Payee equals person or person's bank account receiving the payment. So bearer and order bills. Bills and notes may be either bearer bills or order bills. Okay, a bill payable to bearer is one which is expressed to be so payable, or on which the only or last endorsement is an endorsement in blank. That is one that does not specify a named endorsee. So you have a fiat currency note would fall under this category. The British pound note sterling, because the British pound sterling note even has the language of, I promise to pay the bearer and demand the sum of whatever amount is on the bill, on the note, showing that it is a promissory note. So for present purposes, the person X who is entitled to payment orders payment to another Y by writing pay Y or order or to the order of, okay, on the back of the bill and signing beneath. This is an endorsement from X to Y. X is the endorser, Y the endorsee. The endorsee becomes, for practical purposes, the new payee of the bill. So an instrument which is pay cash or order cannot be a valid bill of exchange since it does not order payment to a person or to order or to bearer. Okay, so I just put in there what is pay to order to clarify for anyone out there still a bit confused. So you've got pay to order describes a check or draft that must be paid via endorsement and delivery. Okay, pay to order instruments are negotiable checks or drafts that are generally written as pay to X or pay to the order of X. The name entered here indicates the specific person, group, or organization that the payer authorizes to receive the money. Okay, pay to order instruments stand in contrast to pay to bearer instruments, which do not require an endorsement. So although the Bills of Exchange Act 1909 provides an express method of converting an order bill to a bearer bill by means of an endorsement in blank, there is no express provision which allows the conversion of a bearer bill to an order bill. A holder is the payee or endorsee of a bill or note who is in possession of it, okay, or the bearer thereof. What are we a holder of? A bearer security, a negotiable instrument. What is the birth certificate? Okay, we all know by now what it is and how we can use that. An instrument is negotiated when it is transferred from one person to another in such a way as to make the transferee a holder of the instrument. Okay, the method of negotiation depends upon whether a bill is a bearer bill or an order bill. A bearer bill is negotiated by delivery. As a result of these definitions, bearer instruments may circulate like cash. Okay, there is no requirement that the transferor be a person who is entitled to the instrument. A person in possession of a bearer instrument is the holder. Okay, exactly the same as if you found a fiat currency note on the street, you would not typically be the one entitled to it compared to the person who lost it and acquired the note from trading their labor. An important point is that the endorsement of a bill serves two very distinct purposes. An endorsement is part of the negotiation process of an order bill. An endorsement is essential to make the endorser liable on the bill. So the Bills of Exchange Act permits extending the bill in the event that there is no longer any room for further endorsements. The extension is known as an allonge, and the endorsement which is written or placed on an allonge is taken to be written on the bill itself. An allonge is very unusual in Australia. In some foreign legal systems, the first endorsement on an allonge must begin on the bill itself and continue on the allonge. This is an obvious precaution against fraud and is to be highly recommended, although the Bills of Exchange Act does not impose such requirements. Okay, conditional endorsements paid to the order of, for example, Jane Doe on the condition that she studies law at an Australian university, so that can be endorsed on a bill, and that will become conditional. So a person signing as agents, okay, this is important now, pay attention. The Bills of Exchange Act 1909 attempts to define the liability to a person who signs as agent or in a representative capacity, provided the person signing the bill is in fact signing on behalf of a principal and adds words to the signature which indicate that fact, and provided the principal is named or otherwise indicated on the bill itself, then the person signing is not personally liable on the bill. So the complementary problem is when the signature is accompanied by words which indicates that the person signing is doing so in the capacity of an agent, but there is some defect in the agency arrangements. So Section 34(1) of the Bills of Exchange Act provides that the mere addition to the signature of words which describe the signer as an agent or as filling a representative character does not exempt the signer from liability. The Act also requires a construction which is most favourable to the validity of the bill when attempting to determine if the signature is that of the principal or that of the agent by whose hand it is written. Okay, so the safest course for the principal is to require the agent to sign per pro. This abbreviation indicates that the signature is affixed by procuration, that is, with the authority of the principal whose name actually appears. Thus, if the agent A signs on behalf of the principal P, then the appropriate form is principal per pro agent. The reason that this is safe is that the signature operators notice that the agent has limited authority to sign for the principal, and the principal is not bound by the signature unless the agent is acting within his or her authority. Okay, and that's case law here to see that fact back in 1932. And here's some more examples as to how you can sign. Okay, so there's different variations. You can have PP, and be basically your signature, and then it's always the name of who you're signing on behalf of, which is every bill that's presented to us, right, is in the name of the straw man. Okay, so that would be the straw man in that instance. So in this particular example, just replace secretary signature for your squiggle. Okay, you can even do just a normal autograph, okay, and a thumbprint, and then the president's name would be the straw man. You could just do any old squiggle. It doesn't matter. It just shows that separation between the two entities. Okay, and likewise here. So it's different variations, so it's up to you. Okay, and now we're going to go into some notes taken out of Bill Turner's presentation on this whole process of acceptance for value, okay, and accessing our set off. So there's the link. So I highly recommend you guys go away and watch that, but then apply it with obviously what we're going to talk about here, what's already gone through, what we've gone through. So a bill, mercantile law, okay, is an account containing the items of goods sold or of work done by one person against another. It differs from an account stated in this that the latter is a bill approved and sanctioned by the debtor, whereas a bill is made out by the creditor alone. The Bills of Exchange Act 1908, bill means bill of exchange and note means promissory note. Bill of Exchange Act, forms, interpretations, okay, we know obviously bill of exchange defined. Section 2, in the instrument that does not comply with these conditions or that orders any act to be done in addition to the payment of money is not a bill of exchange. Now this is important, guys. 3, in order to pay out for a particular fund is not unconditional within the meaning of this section, but an unqualified order to pay coupled with A, an indication of a particular fund out of which the drawee is to reimburse himself, or a particular account to be debited with the amount, or B, a statement of the transaction giving rise to the bill is unconditional. Okay, so the Treasury can either reimburse itself from the prepaid exemption account or simply pay directly out of that account to settle the bill by debiting it. The statement they send you in the post gives rise to the bill, so you can accept it for value with mention of the particular fund and pay to the order of the maker of the bill. Okay, this will become clear later. So a bill is not invalid by reason that it is not dated, it does not specify the value given, or that any value has been given. Therefore, it does not specify the value where it is drawn or the place where it is payable. Okay, so it means that even if it's not specified, the place where it is drawn or the place where it is payable, it's still valid. Okay, and this will become obvious in a second. So if you received your birth certificate / source document, then you'll know that the fund number mentioned above in 3A and B to put on the document. Okay, the bill is drawn in the Treasury. That's the place not specified, as the Treasury is our bank. Okay, you've got the Stamp and Cheques Duty Act, which is quite interesting. This has actually since been repealed. This is from New Zealand, but it did state here, this is where it comes from, the 5-cent stamp. Cheque duty shall be computed at the rate of 5 cents per bill of exchange. I think it's still probably good to maybe stamp it, okay, when you're doing the A4V. As you'll see, there's an example below. But it has since been repealed, and it seems to be a lot of acts in the Commonwealth here in Australia are kind of veering away from using stamps and documents, and that it's not a requirement as much anymore. Okay, but you certainly can, because remember, the only real money in circulation is actually coins and stamps. Everything else is just done through set off money on account. So a statement is a written list of transactions noting money owed and money paid, a detailed statement of mutual demands arising out of a contract or a fiduciary relationship. An account can simply list payments, losses, sales, debits, credits, and other monetary transactions, or it may go further and show a balance or the results of comparing opposite transactions like purchases and sales. So business persons keep accounts, attorneys may keep escrow accounts, and executors must keep accounts that record transactions in administering an estate. And that's certainly what they do on the public side for our straw man. Okay, that's what they're administering. And they're coming after us all the time because they need to service the interest due on all the debt. So the executors are administering our deceased estate. This is why they're sending statements to us. Okay, the Bills of Exchange Act 1908, Section 39, this is in New Zealand. When presentment for acceptance is necessary, 1, where a bill is payable after sight, presentment for acceptance is necessary in order to fix the maturity of the instrument. 2, where a bill expressly stipulates that it shall be presented for acceptance, or where a bill is drawn payable elsewhere than at the residence or place of business of the drawee, it must be presented for acceptance before it can be presented for payment. Now that's huge. Okay, so we know the Treasury is our drawee, which is elsewhere than at the residence of where they send us the bill. We must first accept the bill for value, then send to the Treasury our drawee for payment. Okay, so you're going to see where that's codified wherever you are in the Bills of Exchange Act, which will be in there verbatim, but just maybe under a different section. So discharge of bill, payment in due course. A bill is discharged by payment in due course by or on behalf of the drawee or acceptor. Okay, payment in due course means payment to the holder of the bill made or after the maturity thereof in good faith and without notice that the holder's title is defective, subject to the provisions hereinafter contained when a bill is paid by the drawer or an endorser is not discharged, but where a bill payable to the order of a third party is paid by the drawer may enforce payment thereof against the acceptor, but may not reissue the bill. Where a bill is paid by an endorser, or where a bill payable to drawer's order is paid by the drawer, the party paying it is remitted to his former. The party paying it is remitted to his former rights as regards the acceptor or antecedent parties, and may, if he thinks fit, strike out his own in subsequent endorsements, and again negotiate the bill. Now, this is me decoding what's just been said here for you folks to try and get a better understanding. But meaning, if an original drawer of a bill negotiated the bill to another by endorsement, then the holder of the bill can demand payment by the drawer, and the drawer, once paying the bill, can return to being the payee who holds the rights to receive payment by the original drawee on the bill for which it was accepted and drawn up in the first place, and is then able to negotiate it if they want. Okay, so if you are a holder of a bill of exchange, you can demand payment by any one of the endorsers on the instrument, and if it's presented to someone other than the original drawee, debtor on the bill, then the party paying will strike off their own name and any and all subsequent endorsers that have negotiated the bill after that fact, and return to receiving the rights to payment in negotiation. Now, this is such an important concept to get your head around in regards to visualizing the chain of endorsements and debtors, creditors that have been created from that relationship, that if a holder of a bill of exchange went back to someone that isn't the original debtor, okay, who signed and endorsed the bill of exchange when it was created, that individual who then pays the holder ends up becoming the holder, and so can then go to anyone who's otherwise endorsed it before that point of now the new holder, up to the date of when they endorsed it, to negotiate it to a creditor, that they can go back down the line of all the debtors and claim and present it for payment, okay, by any one of those endorsees, or endorsers rather, on the instrument, okay, and it can go all the way back to the original debtor, who was the original drawee, who endorsed the instrument to create the bill of exchange in the first place, okay, on behalf of the creditor. So very, very interesting or important point to get your head around, guys, when visualizing how these bills are negotiated, because pretty much everything is a debt note, and most of these negotiable instruments, this is what's going on internationally, worldwide, because none of it's closed, because it's discharged. It's still set off into the future, and that's still accruing interest. And like I said, it just gives more appreciation to the fact of the remedy that lies with a private offset account, that we can actually extinguish the debt on the public side and stop this accruing of interest continually for eternity, it seems, or until such time these governments come back to substance-backed money, which is quite obvious that they don't plan to do that anytime soon, unless there's a huge shift of a lot of us coming back to life and demanding a new system through actually governing their own decadent estate and acting like creditors in the bankruptcy by helping to reduce the public debt by doing the right things of private set-off, accepting for value and setting things off and coming back to life and learning about all these aspects of securities, money, banking, accounting, law, our rights, etc. So where an accommodation bill is paid in due course by the party accommodated, the bill is discharged. If we accept the bill by accommodation, the bill is discharged. This is coming from Bill Turner's presentation. So this is his example, what he advocates to do. So you've got the consideration, which is 100 unit stamp. Stamp duty, obviously codified in the Act, which is disputed. It's been repealed. So whether that's necessary anymore, who knows? You guys can certainly try this out. Stamp duty paid 5 cents. Then you've got to write $1 here, which is the real unit value, which is the stamp. So Bills of Exchange Act, accommodation party. 1, an accommodation party to a bill is a person who has signed a bill as drawer, acceptor or endorser without receiving value therefore, and for the purpose of lending his name to some other person. Now, an accommodation party is liable on the bill to a holder for value, and it's immaterial whether, when such holder took the bill, he knew such party to be an accommodation party or not. And then you have Section 3B, a statement of the transaction giving rise to the bill is unconditional. So we know, obviously, what they send in the post is a statement, as you can see here. From previous slide, a statement giving rise to the account, making it unconditional. And then from previous slide, we have signed as acceptor by accommodation. Now, he recommended to sign like this: accepted for value, paid to the order of John Doe, in accordance and satisfaction with Bills of Exchange Act 1908 by accommodation, John Doe. This is what Bill Turner advises. And this is another upload where he goes into the Bills of Exchange Act as well, but he doesn't touch on acceptance yet. It's like a part 1 of a new updated version. And this is my commentary, So tying together everything before, and you'll see some examples here, and then you guys can, go away and make of it as you will, and, try these things out for those who have got their bonds in place with the Treasury, the set-off bond in particular. So I disagree with this method. But discern for yourself and try this out for yourselves. People can certainly try this without having their bonds in place. As we know, if you have a birth certificate, then that's evidence of the account being administered. But I would try out the following, Accepted for value, paid to the order of the name of the company person on the bill, because they're the ones after the money to settle their books. In accordance and satisfaction with Bills of Exchange Act 1909, this is the one here in Australia. If you're in the UK, it'll be 1882. By accommodation. And this is where I'll try, you see there's multiple examples here, but I'll put in my surname with the account upon which the drawee shall be either reimbursed or debited to pay the bill, or exactly the same, but the straw man with, again, the account number, or, pretty much exactly the same, but then you can do PP, so you could do your autograph, given name, or squiggly, or whatever, and then have the strawman birth certificate registration number there. Or again, do the same PP, but your surname. Or you can even use PP when signing by accommodation. If you have your bonds in place, then you may want to cite that also in a cover letter you are sending in with the first initial set-off/discharge attempt with the bill from a company to the Treasury. You would want to cite the section of the Bills of Exchange Act which talks about presenting for acceptance before presenting for payment if the two sites are different. You may also want to organise an agreement through silent acquiescence to require permission to change the address of where the company sends their bills. Rather than sending to your residence, you can have them send direct to the Treasury. So the address with the company sending you bills can be changed to that of the Treasury, which you can use your cover letter and initial acceptance for value as proof of the agreement if needed to influence the change of address with the company you are negotiating with, e.g. utilities company. This is just food for thought anyway. Once you have your bond set up, status corrected and knowledgeable in controlling your security interests on the UCC1, etc., and this whole Bill of Exchange acceptance technology then you can apply this to purchase agreements. Okay, up to you at the end of the day, and best of luck with it. And just to give you an example of how this is applied on the bonds, right? When you do this on the back of your birth certificate, okay, you have the acceptance language here. Okay, as you can see, accepts for value the enclosed instrument entitled birth certificate, numbered, and all endorsements front and back, etc., etc. Used for what? Set off up to the value of $100 million in this instance, but it can be unlimited. And this goes to, the Treasury. If you're going to do a generic Treasury set-off bond, which is basically the same as almost charging up your national insurance social security account, but you can certainly just go direct to the Foreign Insiders Trust, which is linked to your birth certificate registration number. That's the account identifier. And once that's sent in and they haven't rebutted, then you can certainly start negotiating the bills that have been sent to you by endorsing them and signing, accepting for value, okay, and then forwarding onto the site in which it has to be paid by the payor. All right, and then basically the jury, which would be a bank on the private side, which is the Treasury. Okay, and then this guy, once you understand this technology and you can get hold of your birth certificate, which is printed on security stock paper, and what is that representing? It's the account. Okay, it's the prepaid unlimited exemption accounts and all of our unlimited credits that we have the ability to create. And that's what the birth certificate, that's why the birth certificate is printed on security paper, because that is securitized. And that is what backs the bond. So the bond is secured against our unlimited prepaid exemption Foreign Insiders Trust account being administered by who? These trustees. But ever since we took up the agreement with the National Insurance Social Security Trust, it's now pretty much the governments that are administering this for us. Okay, but they're all administering it, and they're all playing two roles. They're either administrators and executors on the public side, if you're still acting like a dead entity, or a trustee on the private side, if you're acting like this, an international creditor, who's here to set off the bankruptcy and no longer a ward of the state or an enemy of the state, and who is come back to life and knows that they are the bank. We are the bank. We, us, our. Okay. And so you can then, again, example, signing on behalf of these entities that we control that are both linked to an account, that these folks, when you send into them, can act as agents for. Because all of these are just shell companies. They need agents to come in and act on its behalf to do anything. Same as a corporation and a bank account. Okay, and only one thing I'll change here is just put also surety. Okay, surety 1, surety 2, but by virtue of just signing it like that, you underwrite it, and these two are accounts, and they know that. And so the principal, which is me in my living capacity, it's been underwritten and is insured with these two entities as surety, which is basically going back to the Crown. And it's showing that I'm no longer accepting the role as surety for these entities. And when you send it over to them and sign like this as PP, shows that separation with that liability, and they're the ones that come in and have to act on behalf of that entity to set things off for you, for the benefit of you, the living individual. Okay, so that basically these entities become what's otherwise codified in a lot of these acts, and the Crown can act in right of. Okay, so the Crown specifically manages and have created the father's name. Okay, that it can act in right of, but then what was given to us was the first name, and so this is like a marriage. It's a joint venture between the church and the state, the living and the dead, and that's representative of the straw man. So we're both entitled to reap benefits from the accounts, and that's why they get paid for administering the accounts as trustees and or administrators or executors, no matter whether you're operating from the public side or the private side, they're still getting paid. It's just one side you're not getting paid, whilst the other you will, and reap the benefits of it. Okay, and this is basically otherwise an extension of the trust indenture that you can then put in your own terms and conditions and control your securities on the UCC, the PPSR, and the sky's the limit, which is why I went back and went over all the definitions of all the different bonds you can use, okay, that you might want to think, oh, yeah, I want to reap the benefits of that, like a permit bond, for instance, and that will insure me then for basically issuing my own licenses. So I don't have to go through the public license infrastructure and be sued if I'm operating unlawfully in that sense, because the permit bond's going to cover me for that. Okay. And so little things like that, it's just a matter of, at this point, knowing what you're doing and have a little bit of fun, and knowing that, you know, you can't do anything wrong as long as you're indemnified and acting honorably and not abusing this technology. You can certainly lock in a lot of very valuable and beneficial contracts with these folks through Silence's acquiescence again. Okay, and that's really important to do, and put in the language there so you can, under equity, you know, lock in that contract. So, and this was just an example for a private insurance bond. So then you can start thinking about maybe dealing with private insurance firms. Okay, this is just for my car. I'm just trying stuff out. So at this level, you should be, you know, using your mind to try things out. But with the Treasury, in regards to accepting bills of exchange that are addressed and presented to your residence, you can certainly accept for value and then forward on to the site at which it will be paid, which is your bank, who is the Treasury acting as drawee for that entity. Okay, and then you can formalize an agreement in order to get them, or get the maker of the bill, whether it's a utility company, for example, to change the address to the Treasury. So every time there's a bill and the accounts need to be settled, they'll just go direct to your bank to have it settled. Easy. And you don't have to waste money on postage and signing every 3 months, or however frequent the bills they send you. If it can't be set up that way, and you've got to accept it and then forward it on, or try and renegotiate with the utilities company to come maybe every 3 months, so you can save paper that way. So you're not sending every month, you know, and it's every 3 months you can do it, or semi-annually, etc. So it's all down to each and every one of us at the end of the day to start now having these kind of conversations when having this knowledge with our bank, okay, public, private side, with these private insurance firms, maybe, in issuing these securities, these negotiable instruments. Okay, this is exactly what that is. So powerful. I can turn this into a promissory note, a check. So I know what it's backed by, the limited exemption account. It's just developing the language and understanding to negotiate it and monetize it. Okay, which I'm learning, I'm trying at the moment. I've got many things in the works. I'm trying to, you know, bear fruit with this process and lock into place. But it's all down to you folks at the end of the day. Okay, and like I said, this I would have changed a few little things just with the sureties down here, and I would have put in the PPSR number that I used to control the security and showed that I assigned it to this individual and all successors, okay, who had taken office within this corporation sole. But otherwise, you have an unlimited, that's a negotiable instrument that you can now use for your benefit. It's a blank check. It's just unlocking the procedures, the processes, and the language in order to do that for you. Okay, so I hope that has been more enlightening for those folks who have done the Advanced Treasury Pack, as it has been for me going through this again and thinking about how I can start utilizing this power now in these securities that you can hopefully go down and get multiple copies of. And it'd be even more powerful if you have space to print them on the back of the bond. If not, just glue them together, okay, and then do your acceptance on the actual birth certificate, whatever it's related to with the bond, and then have the bond attached to that and reference the bond on the certificate itself. But if you can print on the back of one of these, then you're laughing, because there's no question that that's the account that bond is securitized against, which is basically a check ordering the holder of that bond to be able to access the unlimited credits on that account as and when you want to order them to perform. Okay, whether any claim arises for an accident, if you're issuing an indemnity bond, for instance, or any bill for set-off, okay, whether it's a fine, fee, tax, you name it, utility bill, etc. You can start using the Treasury now as trustees, coming back to life as a beneficiary in order to set things off. Right, so let's finish off the rest of these notes. So inchoate bills, if the bill is signed by the drawer and delivered to another person in order that the bill may be completed, then any person who is in possession of the bill is prima facie deemed to have the authority to complete the bill in any way the person sees fit. The acceptor of the bill is the person primarily liable on the bill. So stranger signing the bill, there are times when a person signs a bill, but he or she is clearly neither the drawer or an endorser, nor if the bill is a time bill, is he or she the acceptor. The reason for such a signature is to back the bill. That is to lend the credit of the person signing so that the bill becomes more valuable. The person so signing is said to be a stranger of the bill, which is basically an underwriter, which is what we can do, as you saw, name of the father and the straw man, sign on behalf and underwrite for the benefit of us, the living. So presentment for acceptance. A bill must also be presented for acceptance if the bill specifically requires that it be so presented. Okay, finally, a bill must be presented for acceptance if it is drawn payable at some place other than the residence or place of business of the drawee. Now, you need to find this in your act and quote that in your cover letter. It may work with the cover letter, but you may want to, get that agreement to change the address. It's completely up to you guys. That's what I mean. You can have a bit of fun with this now, this technology, and there's no harm. You can just start liaising, having these conversations and trying things out. So presentment for payment, unless otherwise excused, a bill must be presented for payment. If not duly presented for payment, once again, the drawer and endorsers will be discharged. The only way in which a bill may be presented for payment is by physically presenting the bill to the drawee. Section 50, subsection 2 sets out the time and place where various types of bills must be presented. Okay, delay in presentment is excused if the delay is due to circumstances beyond the control of the holder, provided the circumstances relied upon are not due to the holder's default, conduct, or negligence. In certain circumstances, presentment for payment is not required. These include where the drawee is fictitious. That's quite funny because obviously, it is a fictitious entity, but they would not be willing to admit that. Plausible deniability. Finally, where a bill is presented for payment, the holder must exhibit the bill and upon receiving payment, give the bill to the party paying. That's exactly what this technology is unlocking, that Bill Turner alludes to, by signing through accommodation. Or we can just do normal PP, acceptance, signing without liability. A bill is discharged when it is paid in due course by the drawee. Check washing is a term used to describe the use of chemicals to eliminate the written words on a check so that they may be replaced with ones more favourable to the rogue. The use of special paper by banks has reduced the threat posed by check washing. I mean, we've got one better. We don't have to even, do that kind of those activities because we have a blank check in the form of our birth certificate. Okay, it's just learning how to unlock the monetization of it. So other forms of discharge, certain bills known as accommodation bills may be discharged when payment is made by the party accommodated or the Bills of Exchange Act 1909. Sans recourse, this means that even if the original agreement is not honoured, the endorser cannot be held responsible. This permits the endorser to transfer the cheque by negotiation, but without attracting any liability to later holders of the cheque. Okay, so that wraps up all the notes taken from the book under that subject, I'm pretty sure. So what's left is just a few more definitions, okay, that we'll go through in relation to accommodation bill. Is a bill of exchange, the purpose of which is to provide financial support or credit accommodation to a person. 2, for the purposes of Bills of Exchange Act, a bill of exchange in which the party providing the accommodation is the acceptor. And 3, a bill of exchange signed by an accommodation party. Okay, this is the whole tactic of what they hope for, that someone, i.e. us, will step in and lend our credit to some other person to help settle a bill. Who is that other person? Our straw man. It's a form of becoming surety for the entity on the bill. That's why I believe it makes more sense to use the name of the father, surname, birth certificate, registration number when signing by accommodation, as it clearly shows the Crown being charged with the honours of accommodating the bill. Using the straw man, birth certificate registration number will also work in my eyes too. Okay, so the birth certificate registration number is important as that identifies the account/fund for the Treasury to debit or reimburse themselves when settling the bill. Do what feels best. There are options for you, just as long as you understand fully what you were doing before you were doing it. That's 70% of the victory. Now, when I watched the Bill Turner presentation and I was seeing paid to the order of John Doe in accordance satisfaction from ASB, who is sending in the bill, that's the maker of the bill, so it should be paid to the order of ASB, who is demanding the settlement of the account. So I wouldn't pay attention to that. That's why I don't agree with it, because it doesn't make sense going through what paid to the order of means and who's actually presenting the bill to you as maker of the bill, who's saying, look, you owe me, this is what I need in order to balance my books. So, I can come back into honour under this bankruptcy, that you do not want to be paying to the order of your straw man. So that doesn't make any sense, because it's obvious that it's coming from ASB addressed to your straw man. Okay. And then we do what we do in order to accept it without liability and forward it onto the Treasury to set off. Okay, and that's otherwise, what I didn't agree with there, because that obviously clearly doesn't make any sense with what he's trying to do. I think he's probably a bit confused, unless I'm missing something. Okay, but please let me know if I'm missing something in that. So I'll be very interested to hear what I may be missing. Where are we? So we go down here, definitions, that's right. So accommodation party, a person who has signed a bill as drawer, acceptor or endorser without receiving value for that signature and for the purpose of lending their name to some other person. An accommodation party is liable to a holder for value. Okay, as you can see, it's never good for us to be an accommodation party to a dead legal fiction entity, as that relationship will have us pay from our hard labor rather than our unlimited exemption when signing and accepting correctly. All right. So we've got account is a written or verbal description of a facts or of an event. There's also a statement explaining the event. Okay, banking and finance is a facility or arrangement by which a financial institution accepts deposits or allows withdrawals of currency, pays checks or payment orders drawn on the financial institution by another person, or collects checks or payment orders on behalf of another person. Okay, and you've got these other applications and corporations. Okay, is a formal record of financial transactions such as in a ledger, journal or balance sheet. It's a facility for arrangement with their business for the supply of goods or services without immediate payment. And 3, it's kind of like accrual accounting. And 3, the amount of money owed for goods and services provided, such as a bill, okay, which is obviously what's sent to us from a lot of these corporations. Equity, a former common law action requiring a person entrusted with property, for example, a guardian, bailiff or receiver, to hand it over. And then we've got the Personal Property Securities Act. Okay, for the purposes of that act, the obligation must arise either from disposing of property or from granting a right or providing services in the ordinary course of business of granting rights and providing services of that kind. Account would include, for example, a credit card receivable and a book debt. It does not include an authorized deposit-taking institution, account, chattel paper, an intermediated security, an investment instrument or negotiable instrument. A transferee's interest under a transfer of an account is deemed to be a security interest. Okay, you've got some more here. Under accounting is a detailed statement of the debits and credits between parties to a contract or to a fiduciary relationship, a reckoning of monetary dealings. The trustee balanced the account at the end of each month. In wills and estates, an account is a brief financial statement of the manner in which an executor or administrator has performed the official duties of collecting the estate's assets and paying those who are entitled. An account charges the executor or administrator with the value of the estate as shown by the inventory, plus any increase in credits the executor with expenses and costs, duly authorized disbursements and the executor's commission. Okay, we've got accounts payable. It's an account reflecting a balance owed to a creditor. An accounts receivable is an account reflecting a balance owed by a debtor. And we have an escrow account. It's a bank account generally held in the name of the depositor and an escrow agent that is returnable to the depositor or paid to a person on the fulfillment of specified conditions, which is obviously what's used with the off-ledger activity, with the trust, lawyer's trust account, etc. Google definition, the escrow agent is an independent third party in charge of holding the assets, documents, and or money in escrow until the contractual condition is fulfilled in the terms and conditions established by the parties in the escrow agreement. The escrow agent might be a natural person or entity. We have a margin account. It's a brokerage account that allows an investor to buy or sell securities on credit, with the securities usually serving as collateral for the broker's loan. And the same concept can be used, guys, whenever you can maybe within a business show on the books, right, that you've got an accounts receivable in the form of maybe, say, a bond, okay, that's held with the treasury up to a certain value, whether it be a sell-off bond, discharge bond, indemnity bond, or even a promissory note. That legitimately, if you know how to do proper accounting, can then be shown on the statement of accounts to a bank to extend your line of credit. Okay, and then you can do what you do with that line of credit in regards to that promissory note that the bank gets you to sign to release that credit on an account of zero balance that you're then creating that you can accept for value, send off to the treasury to set off. Okay, so you know what I mean? The sky really is the limit. It's just going over this and becoming familiar with the banking terminology, and now knowing how to negotiate these instruments and securitizing it to your prepaid and limited exemption account, which is your birth certificate. That's a security that's already been underwritten and issued internationally that can be negotiated. Okay, so you have a nominee account is an account in which a named person or entity holds assets on behalf of a beneficiary. In securities law, a brokerage account in which the securities are owned by an investor but registered in the name of the brokerage firm. certificate and the records of the issuing company show the brokerage as the holder of record, but the brokerage records show the investor as the beneficial owner of the securities in the nominee account, also termed street name security. Remember, DTCC holds all legal title to all securities trading in the markets. There may be some proportions held by other depository institutions in other regions, but the DTCC will certainly have the lion's share. Also called brokerage accounts, who act as the middlemen for investors, will only hold a color of title to that security and street name. So to keep the transfer of so-called ownership, which is more equitable title as beneficiary, not the actual owner, fast and efficient when settling and clearing trades in the market at the central depositories who hold legal title. Thus, again, anyone purchasing securities in the market will be operating through this nominee account, where you merely have the right to receive equitable title and interest in the asset, but don't retain legal title. Offset account is one of two accounts that balance against each other and cancel each other out when the books are closed, private, public. Okay, that's what we have access to on the private side. There's a few other definitions there, quite rudimentary. Under settlement, we have a payment, satisfaction, or final adjustment. Okay, an adjustment with regard to accounts, settlement of accounts. Okay, a fixed time or period for settling the accounts or concluding the transaction. Closing. The settlement on their new house will be Friday at noon. Under wills and estates, the complex execution of an estate by the executor. All right, so this kind of the language that you can start using and utilizing now, knowing about this technology that you want to definitely put forward on in your letters, right? Correspondences with these guys, no matter what you're trying to set up and get done. Discharge, to relieve oneself or to be relieved of an obligation or duty. Under bankruptcy is the process by which a debtor who has been adjudicated a bankrupt is released from all the debt or debts provable in the bankruptcy. Discharge affects the status of the debtor and not the bankruptcy itself, which may continue until the trustee completes the administration of the estate. Then discharge again is any method by which a legal duty is extinguished, especially the payment of a debt or satisfaction of some other obligation. 2, a bankruptcy, the release of a debtor from monetary obligations upon adjudication of bankruptcy. Discharge and bankruptcy compare with release. Automatic discharge, got set off there again, under banking and finance, is a common law right by which a debtor is entitled to take into account a debt owed to him or her by the creditor when sued for a debt due to the creditor. To exercise a set-off, the debt must be a certain sum due by and to the same parties and in the same right. The statutory provisions relating to mutual credits and set-off in the case of bankrupts do not rest on the same principles as the right of set-off between solvent parties. In Bankruptcy Act, also known as combination, see also banker's lien, right of combination. 1, a cross-claim for money by a debtor against a creditor that operates to reduce or extinguish the creditor's debt. Where a bankruptcy notice is served on a debtor, the notice is satisfied if the debtor has a counterclaim set off or cross demand equal to or exceeding the amount of the judgment debt claimed in the bankruptcy notice. 2, the process of adjusting claims to the bankruptcy by which a debt owed by a bankrupt to a creditor is reduced or extinguished by mutual claim which the bankrupt has against that creditor. Again, there's obviously more explanations and commentaries surrounding the set-off, which you guys can read through in your own time. And that wraps up the Bills of Exchange presentation. Okay, so hopefully in the next presentation, we'll whiz through the rest of the pages, which are going to go over, again, some pretty interesting concepts surrounding checks, payment processes and technologies. Okay, bit of cryptocurrency decentralization, the payment systems, okay, and securitization, especially from looking through a lens of a banker, okay, with the banker's lien, etc. Okay, so we'll hopefully in the next presentation get all of that finalized, or at least within the next 2, and wrap up this mini series on banking law, which has been very, very enlightening to say the least. If I can speak for myself, I'm sure I'm speaking on behalf of many others going through this too. All right, so hope that has been very enlightening for you folks. You got a better understanding as to accepting for value, what a bill is, and what our remedy is, okay, on the private side when dealing with presentments coming at us from the public. Okay, right, folks, I'll see you over the next one then, and stay safe as always and study hard, and ciao for now.